Hey, it's Michael. If you've been on a Zoom with me lately, you'll notice that you have my full attention. It's because I'm not taking notes. Instead, I rely on Fellow, an AI meeting assistant, to take notes for me, along with tracking action items and decisions, handling recordings, transcripts, and summaries all in one secure platform. It's kind of like magic. Built with security and privacy at its core, Fellow is the only AI meeting assistant that thousands of leaders and organizations trust to capture meeting notes and recordings while keeping your data safe. They're so confident that you'll love it, they're offering an insane deal to you all, Between Two COOs listeners. 90 days of unlimited AI-powered note-taking and recording completely free. Visit fellow.app/COO to sign up today and experience the AI meeting assistant trusted by leaders everywhere. Welcome back to another episode of Between Two COOs. Today we're diving into one of the hottest topics in AI and privacy with a returning guest, Flick Fisher, a leading expert on EU privacy law. If you've tuned in before, you'll remember Flick's deep insights on GDPR enforcement, data transfer, and AI's legal risks. But today we're tackling something even bigger, the EU's Artificial Intelligence Act. It's officially law, and it's setting the bar for AI regulation worldwide, which matters if you're a US company with global ambitions. We'll cover what this means for businesses using AI, the compliance headaches companies need to prepare for, and how this law fits into the broader EU privacy framework. We'll also explore the latest regulatory actions, including recent enforcement cases, and discuss what's next for AI regulation both in the US and EU. So, if you're a COO, founder, working on product, or anyone navigating AI in business, this is an episode you don't want to miss. Let's jump in. Flick, welcome back.
Yeah, thanks very much for having me. It's my favorite topic.
Naturally, it's your job. It better be your favorite topic.
Yeah, it's a good one.
First off, please, can you give me a refresher on what the EU's AI Act is?
Yeah, so the EU's AI Act is really the first comprehensive piece of AI legislation that we've seen globally implemented. It's the first of its kind, and it sets to regulate AI systems with the goal of making sure, really, that deployers and users of AI systems are doing so in a transparent, safe, an ethical way with a sort of human-centric approach, and that we have a sort of risk-based way of making sure that certain AI systems that we think are just not tolerable to society should be prohibited, and other AI systems that we deem to be high risk. There are certain sort of requirements that need to now be complied with if you're going to be deploying those high-risk AI systems. Then it also introduces some general sort of good hygiene transparency requirements for other more sort of limited risk AI systems to make sure that people are aware that they're interacting with an AI system like a chatbot and other things. And also some rules, specific rules if you've got a general purpose AI model. So your generative AI tools, they are also specifically regulated under the Act. So first of its kind, and I think it's triggered many other countries around the world to look at their own regulation of AI and perhaps take some inspiration from that. We'll wait to see what happens there, but it's Europe leading the way with AI regulation.
So, in terms of the actual contents of this, how is the EU going about just making sure that things are safe, ethical, transparent with a human-centric approach? It seems rather daunting with something as huge and unpredictable as AI.
Yeah, they've tried to create a piece of legislation that is flexible and is going to be future-proof to some extent. Because we know that this is a space which things are changing by the day. We've got vast and rapid sort of technological developments there. So they've tried to create a piece of regulation which is going to keep pace with that by having a very much a risk-based system. So as I mentioned, they've sort of identified certain AI systems which they deem to be so risky to society that we really need to take steps to prohibit them. And actually, that is where we see the first sort of area of the Act coming into force. The first provisions of the Act came into effect, and these are really some general AI literacy requirements, which we can talk about in more detail. But also, we've got the first prohibitions of certain AI practices coming into effect. And as I mentioned, these are really sort of AI systems where Europe's saying we are not going to tolerate these types of AI systems being placed on the market in Europe. And so we're really talking about AI systems that are doing things like deploying subliminal techniques or manipulative or deceptive techniques to distort someone's behavior with the intent of really causing significant harm. There's also any AI system that's really going to exploit vulnerable people, so children, anybody with protected characteristics like disabilities, etc., if there's an intent to cause harm with the AI system there. It also prohibits what we call social scoring. Again, if that social scoring is really intended to cause significant harm or unfavorable treatment to individuals. So I think people are fairly familiar or have heard about some of the social scoring that may have been happening in China. It's really trying to get at that type of activity. So if we're doing lots of kind of creepy profiling of people to generate automated scores, which would then be used to treat people in a detrimental way, then that's just not going to be tolerated in Europe. If you've got an AI system that's being used to predict someone's risk of committing a criminal offence, and that's based solely on profiling somebody or assessing automatically their personality traits and characteristics, not allowed. We've also got the sort of clear view model, which is scraping lots of images of people to create a facial recognition database, not going to be tolerated in Europe. And then also, which I think is quite relevant for lots of companies, which is if you're using systems to infer the emotions of people in your workforce or in educational institutions. So if you perhaps have CCTV or video footage, which you're placing in a workplace to record people and then inferring their emotions. Are they angry? Are they sad? And using that to treat them in a certain way. Does that feed into their, appraisal that year? That kind of thing is not going to be allowed either. And then there's certain sort of biometric categorization of people to deduce or infer more sensitive categories about them, and other sort of remote biometric identification systems in publicly accessible areas for law enforcement also going to be prohibited as well. So I think the initial task for people is to have a quick check on what they're doing in terms of the use of AI systems to check whether or not anything that they're doing may fall within that prohibited list of AI systems, because they are no longer allowed. And Europe's not going to start fining you yet until August next year, but that is a live piece of law. And so you be minded to just check and review what you're doing to make sure, again, that nothing is on the prohibited list.
It almost sounds like the folks who crafted this just went through all of the movies about AI that have come out and said, yeah, that was problematic in that movie. We should write that in. What I'm very curious about is how people actually go about enforcing these types of things, how it's discovered, and then how it can come to light. What does this look like in practice?
Yeah, it's a really good question. I think we've yet to see how Europe will and how the regulators will enforce this. But we've now got the EU AI Office, which has been tasked with producing guidance, enforcing the new regulation, and they've staffed it up with lots of staff members. I think it's fair to say that I can't really imagine that the regulators are going to come and do a dawn raid on your organization to see whether you're undertaking prohibited practices. I think it's more likely that it would come to light because you get a disgruntled employee who feels that you've used a piece of technology, an AI tool that's being used to treat them unfavorably, perhaps because you're doing emotional recognition or there's some nefarious scoring going on. Or it could be that you have a consumer facing product and individuals say, look, I just think this type of AI system is being used to score me in a way that's entirely detrimental. I can't get access to basic services because you've created this score about me using all kinds of data sets that are unrelated to this particular activity, and it's being used to treat me unfavorably. And at that point, they could issue a complaint to the regulators and there may be an investigation. So, like all of this, I think we've got to see how that settles out. But I suspect the big risk is really just from consumer, individual employee complaints coming into regulators because they feel that something is being done or rolled out in a way that's in breach of these prohibitions. And then, of course, there's always that sort of, does this law really have any teeth from a fining perspective? And like the GDPR, there's the ability for regulators to issue big fines. On paper, that's 35 million euros or 7% of your global turnover of your group of undertakings. So they've given it some teeth there.
You just started talking about GDPR, and that was kind of one of the things that I was going to compare this to. But setting that aside, what we have here that I think is very interesting is a prescriptive list of things you cannot do. And this is really a thought experiment. However, AI, as you mentioned previously, is developing from day to day. Will this be something that is constantly updated? And if so, how frequently? Because this moves much more quickly than something does in the States.
Yeah, I think that's a fantastically insightful question. So I think that there are various provisions in the law which kind of say we have the ability to, for example, add a list of AI systems or categories of AI systems which we treat as high risk. So I've just talked about the sort of AI systems that are clearly prohibited. But there is a second bucket of AI systems which aren't prohibited per se, but are going to be regulated as high risk. And there is at the moment what's positioned as a non-exhaustive list of the types of systems which will be regulated as high risk, but the regulators reserve the ability to add additional systems there. There's also much of what's set out in the law needs to be accompanied by codes of conduct and guidance, which are going to be issued by the AI office. And so I think that provides them with some additional flexibility to flesh out and put some meat on the bones of this regulation in terms of how it should be practically implemented. We know what the law says, but we don't at the moment have a really clear understanding of how companies are practically supposed to interpret some of the provisions there. So I think there is room there through guidance, changes to the law in the future to manage and keep pace. But of course, we know the European legislation has a history of falling behind the pace of technological developments. It takes a long time to make changes to law, to issue new law. But certainly there has been an attempt here with this regulation to try and create a framework approach that isn't specifically boxing itself into a particular sector or anything like that.
We've seen some of the main LLM companies, for instance, OpenAI, they do something which is not uncommon, and that is releasing new features within the US and holding off until things get sorted out within the EU or they're ready to do that. Is this a practice that you would advise other US companies to emulate, or is it just go ahead?
Yeah, it's an interesting one. I think it really depends on your your sort of appetite for risk, but also the sector or the product that you have. Now we know generative AI and the tools that have been pushed into the market by OpenAI and others, and more recently DeepSeek, who's created quite the splash there. We know that they are a huge target for regulators, in part because there's a huge wealth of privacy activists and consumers. Policy groups are very worried about the real world impacts of lots of these generative AI tools and the use of consumer or individuals' personal data to train these models. There's also a lot of fear that we don't necessarily fully understand all of the potential impacts at this point. This is all to say that if you were, bringing to market an LLM, then you should be aware, as we've seen trailblazed by OpenAI and others, that the regulators are going to ask you questions. They're going to want to understand your privacy program, your privacy narrative. So if you have an enormous risk tolerance and you think we're just going to go to market anyway, it should come with the expectation that you will get regulatory questions and that there is the power, as we've seen, a number of the regulators exercise this ability to block a new product from operating in Europe if they think that it has been launched negligently without any regard for European privacy requirements. And I think DeepSeek is currently taking the hit there because we've seen regulators across the bloc come out. The Italians were off the block first again, the Garanti, and said, no, you cannot use or you can't process Italian user information through your chatbot. We don't want it in Italy until you've addressed these privacy concerns. I think the interesting thing we've seen with DeepSeek is they've now said, don't care what you say, we're not subject to the GDPR. So It's going to be an interesting battleground there around some of their attempts to push some jurisdictional arguments and say, nice try, regulators. We're not established in Europe. What we've done today hasn't been subject to the GDPR, so we're just going to crack on anyway. I think that's going to be an interesting one to watch play out. But at this point, I think there's not a regulator in town who hasn't issued formal investigation against them, or in the case of the Italians, they've obviously gone one step further and said, don't want your product in Italy.
It's so interesting also because the DeepSeek Italy kerfuffle that you're referencing happened before DeepSeek put out R1. So you've been on top of DeepSeek far before everyone else. I wonder, you have such an interesting view into companies as they're developing their policies and how their procedures for product development or go to market, whatever it may be, changes over time to fit with the regulations and comply with them. With GDPR rollout, it took people a moment to catch up. And then I think companies started to think privacy first while they were developing. Like, are you seeing a similar pattern here with AI where people are now catching up, or it's too early still?
It's a great question because actually I think the world is witnessing what's effectively an AI arms race, right? This technology is moving at enormous pace, and there are investors who are demanding that we get product to market quickly and we get return on investment. And there's been vast investment into, if we're talking about generative AI tools. And so against that sort of backdrop, I think that we're moving fast and breaking things. Companies are pushing product at great speed, and there's not necessarily the ability against that pressure to keep up with pace, to do all of that, have your perfect compliance program in place, or have done that prior consultation with the regulators, which is what they would love. They would love every generative AI company to come and have tea with them in the UK and talk about what they're about to do before they launch. Not something that everybody is able to do given the breakneck speed of which they need to launch. And even though regulators can be slow, and if you get caught up in that wheel of dialogue with them, I don't think that's always practically possible. But it's fair to say that you cannot get a product to market in Europe and keep it on the market without having to pay lots of lawyers to keep it live for you, because you're going to be fighting regulators day in, day out, unless you've put in place and had some regard for your privacy program. And there's the hot topics that all the regulators are really concerned about. Are you being transparent with users? Have you thought about children when you're rolling out these tools? Have you got age verification measures to make sure we're not offering this product to people that children, vulnerable teens, or others that shouldn't be accessing it? There's a huge focus on what data are you using and scraping to train these models. And it feels like for many companies, this is publicly available data. Surely we should be able to access and use it to train our model. But there are so many issues there, both from a privacy and IP perspective, and regulators are jumping on that and saying, no, people have put their information out there. They may not have fully understood that you're now going to use it to train your model. And we can go into whether or not we think that argument is valid or not, or we're not going to go into that. But that's the sort of regulators' view is, hey, people are losing control over their data here, and we need to give them transparency and we need to give them choice about it. So you will have seen, or may not have seen, that obviously the Italians issued an enormous 15 million euro fine against OpenAI for breaches of the GDPR back in December. And a lot of their concern was just what I talked about. You've been using data without the right transparency to train your models. And we know you don't have a direct relationship with those individuals because you've scraped it from the internet. But we don't care. You've now got to go and do a massive, expensive public campaign on media outlets, on websites to push information, to tell people what you're doing with their data and to let them know the choices that they have. So these are issues that regulators care about, and going to market without any regard for that, you could come up against some issues if you're in that space.
And oh, the irony. We have OpenAI getting this fine, and then OpenAI turning around and pointing a finger at DeepSeek, saying that you trained on ours. Oh, it'd be funny.
It's a horrible feeling, isn't it? Someone's scraped your IP. Yeah. That's what they say.
It's quite insane there. You mentioned the words arms race, and I don't think you meant that specifically, but I am curious. There are geopolitical tensions that are arising from this. You talked about how a Chinese company, DeepSeek, is saying, Italy, we don't really care. But also, Chinese companies are imposing their own regulation, or rather, the Chinese government is imposing their own regulations. Do we see a potential scenario where AI regulation could actually become a trade issue between the US and EU, similar to data privacy laws? And the reason why I ask is we have the EU moving very quickly in quotes, per the legal process, to impose regulations. And then now with the new administration,
Not wishing to get too much into politics here, but obviously with the new administration, we've already had them signal, as you say, a sort of move to deregulate, and particularly to deregulate some of the work that the Biden administration had done through its executive orders to implement frameworks to ensure a safer sort of development of AI. Biden was instrumental in establishing the NIST group and the NIST framework, which has become a sort of de facto gold standard governance framework if you're designing and developing AI tools. Obviously, he's mandated anyone in the public sector who's procuring AI systems should be checking that these AI systems have been developed with that NIST framework in mind. And we see that kind of dissolving with some of Trump's plans there. And I think as the US deregulates and Europe regulates up around AI, I think it's going to almost potentially push Europe into a sort of stronger line of regulation to make sure that we're standing up to or providing a sort of bulwark against some of the threat that deregulated AI presents. But of course, that could come at the expense of innovation and other things. So there's a balancing act there. And I think Europe and the UK are certainly trying to find their feet there to figure out how we make sure that we're protecting people's human rights and we're protecting them against the detrimental impacts of unregulated AI. But also, these are places where, certainly in the UK, the government is keen to make us the centre of AI. And that remains a political tussle. How do we manage that while also making sure we're protecting individuals? I think it is going to be an interesting space to watch as the US goes in a very different direction to Europe.
there are two broad applications of AI that I want to draw out here. The first is from a product sense. I am a company building an AI product. I'm going to deploy this and sell this. And then there's the second, which is I am an operator and I'm going to deploy AI within my internal operations for whatever purpose. If you had to advise a US company that's starting to deploy AI today, or even an EU, but maybe let's focus on the US, how would you advise them to go about this in an intelligent way so that they're not going to get down the road and get into some trouble potentially quickly?
Yeah, very good question. So I think a lot of it will come down to having a good governance program within your organization. I think most sophisticated or most companies that we work with in the US have got some data governance program in place to deal with privacy issues. I think that needs to be built out if we're starting to deploy and integrate AI into our tools, particularly if that's a customer facing tool. I think we need to expand on existing data governance practices to make sure we're capturing the new and novel risks and issues that arise from integrating AI. And that doesn't necessarily require that we completely reinvent the wheel, but at the very least, we're adapting our policies and risk assessments and notices and other things to make sure that we're capturing what we're doing with AI. And that starts at a very basic level. Do we actually know what AI systems we're using within the organization? So if we've done some sort of model inventory exercise to track what's been integrated, what's being developed, what's being deployed out there, do we understand the supply chain behind it and the contracts that have been signed up to and what data we may be giving away when we integrate those AI systems? So I think there's a basic hygiene exercise of understand what you're actually using, what you're planning to develop or use, making sure we've mapped that and that there's a way within the organization to keep track of that, because it can quickly spin out of control and everybody's signing up to new AI features and without really a thought for what that means, both internally for your employees, if you're using it with your sort of HR tools and systems, but also with your customer facing features. There are going to be implications there, and it's very hard to understand those unless we've got a good understanding of what we're starting to use. So there's a piece there. And I think it's about adapting existing risk assessments that you might be doing to integrate unique issues that we need to think about from an AI perspective. And it goes beyond privacy. There are also IP issues as well to think about there, for example.
I love chatting with you because not only are you a very talented attorney, but you're also incredibly pragmatic, which is one of the things that makes you exceedingly talented. You're on the bleeding edge of this. What is one thing with AI that you're thinking about where you're just like, this totally freaks me out?
No. Oh my goodness. That is a difficult question. I have the sort of privilege of getting to lift the lid on lots of what companies are doing. And I think the bit that really freaks me out is the increasing introduction of AI bots to do more HR type activities, recruitment activities. I think that's an interesting one to watch there. Next time you do an interview, may not be with a human. Next time you do your appraisal, are we rolling out the HR bot to do that? Or next time you get fired, it's not going to be your manager that does it. And that's quite an interesting space there.
If you remove the human element from the actual human element of a company, it becomes quite dangerous.
Yes. And then at a personal level, I do worry about the threat to information integrity that comes from using these tools. I think there is a real risk of misinformation and losing that source of truth for information. And I think that poses threats on all kinds of levels to society, democracy, all kinds of things. But that's a huge topic. And that's not so much, that's more of my sort of personal feeling about some concern I have.
Certainly, there is no longer one single truth anymore.
I think there's also a real issue around people losing their critical thinking because we are starting to think that these tools speak the truth and we're not interrogating the information that comes out of them in the right way. I think what we currently have are tools. They're not a replacement at the moment for that layer of critical thinking, which is so important. And we should be evaluating information that we gather from these tools. I guess I don't know whether the analogy is aeroplanes we've long had, they've been driven autonomously, but you hope that the pilot knows how to fly the plane. It's a crash. And they're still applying important thinking that goes on to do that. I'm not sure that's the best analogy, but I think we need to remain alert to the need to continue to interrogate information sources and think about issues for us and not regard a lot of these sources as our replacement.
So we were talking about governance. Getting back to that real quick, when you think about advising companies on implementing these, what are some of the misconceptions or wrong turns that you've seen some companies take so far when implementing that governance and compliance aspect?
Yeah, I mean, I think it's fair to say everyone talks a lot about governance, but I'm not sure that people are scrabbling around for how to practically do that. The more sophisticated companies are looking to like the NIST frameworks or the ISO frameworks to try and put in place governance. But as you say, for the most of the smaller companies where they're still struggling to put in place basic privacy compliance, the idea that we now have to have this sophisticated spun up governance program is too much to stomach, and there's just not enough bandwidth to do that kind of exercise. But I think in the midst of that, at the very least, there are some really important hygiene things that you can be doing. So when you sign up with vendors who are offering you generative AI or AI tools to integrate into your own product suite, just make sure that you have a good understanding of what data they may be wanting to use from you to train and improve those models. Because that reuse of data could put you out of step or in breach of your own customer commitments that you've made. So if you're a processor and you have a great new SaaS tool and you've now integrated AI features, and at the back end you may have a GPT-4 or whatever you might be using, just make sure that you're not giving away your customers' data to train that model without having thought about whether or not you have the permissions from your own customers to do that. I think it's very important to also understand what testing has been done at the back end on these models. What are the limitations of them? Because you could be taking on liability in the middle for those features without having an understanding of where the flaws are and what the disclaimers should be when you put that feature out and incorporate it into your own product. And then security is obviously really important as well, making sure we're not sending information into a third party who has not got their security measures tight enough to avoid breaches, which could be very embarrassing for you. But also, you don't want to see your customers or your own confidential information regurgitated out the back end of these models because there's memorization issues and all kinds of things like that. So I think you need to go in with a critical eye to how these tools are going to be processing information, whether it's going to be secure, whether they're going to respect the use rights that they've contractually signed up to.
One of the things that I think is super interesting about this, and there are obviously so many, is that previously when we talked about privacy and data privacy, it was always around how are companies using our information, and is that ethical? Is it transparent? Part of the story and debate is how are countries using that information, and is it a potential adversarial relationship, and how does that contribute?
I think AI has become so politicized at this point, to your earlier comment, and there is, with everything that comes with AI at the moment, there's this sort of background fear that's thread into the narrative of, if you use DeepSeek, the Chinese government's going to get your data. If you use OpenAI, the US government might get access to your data. So it continues to be an injection of fear around governments getting access to data because of the international transfers that happen, because all of this AI from a European perspective, the innovation is all happening outside of Europe at this point. They would love to say that they're leading the way in AI innovation, but we can't say that right now because, it's clearly all coming principally out of Silicon Valley at this point, and China now that we've got DeepSeek and others. So I think there remains an ongoing concern around what that means for European users when their data leaves Europe and the safeguards that it's used to there and is then processed by these companies that are based in countries where we don't have the same protections for data because of the privacy regimes. And I think those fears are only going to get heightened, say, with the Trump administration and the obvious disregard already for privacy law, even in the US. So
Interesting. And of course, this creates opportunity for companies within Europe to develop AI with some sort of compliance with European standards. There are a couple that I'm thinking about that are certainly on the edge, and the EU is a big enough market that could be something that is quite enticing. Flick, last question for you. Pulling out your crystal ball, given what we're seeing in the EU and the US, where are we in terms of AI regulation in 5 years?
hopefully in 5 years, we know in the next 5 years, the AI Act is going to gradually come into force. So we've got this sort of staggered time frame for the various parts of the Act coming into effect. Those who are going to be regulated as high-risk AI systems, that's coming in next year around August, and then it carries on. There's various timeframes. So hopefully in 5 years, we know all of the provisions will have come into effect, and we'll start to see how people practically comply with the law, whether any changes are needed, as you say, to adapt to evolving circumstances. But I think it's very hard to have a sort of crystal ball gaze on what regulation at this point, because I think the space is changing so much that we almost certainly know that the law won't be able to keep pace. I don't think Europe has got any other plans for a major other new EU AI type act. We've got the AI Act, and now they've got to put it into effect, enforce it, produce all the guidance. That's a vast amount of work for them to do. So I can't see any major additional changes there. We know there's a bit of law on the books around sort of product liability. So starting to expand out the existing product liability regimes to account for defective AI systems and what that's going to mean. So that'll be an interesting area to watch. I think what's going to be more interesting is where the rest of the world goes and whether or not this famous Brussels effect actually reveals itself. So are we going to see other regimes and countries, I should say, around the world be inspired by the AI Act to implement their own regulation? We're starting to see that happen in various places. The UK is taking an interesting approach at the moment, which is that we're going to go with a principle-based approach. And we're not going to have an equivalent AI regulation in the UK. The Labour government has just issued its plan, its sort of action, what it's calling an action plan or opportunity action plan for AI, where it's signaled, its goal to become an AI maker, not an AI taker, is their language. And they're trying to lay down some foundations to improve the infrastructure, investment, resources, AI talent. There's all a big focus on that. I don't know whether or not that's going to have an impact, but we'll see where the UK goes. But yeah, the rest of the world is the one to watch, and how we start to see AI regulated. I don't think places are going to go quite as far as the EU AI Act, which is seen as landmark regulation because it's so comprehensive. I think other countries may take a slightly more pragmatic approach and want to make sure that they're not stifling innovation in a way that people fear the EU AI Act could for Europe. So yeah, one to watch there.
I look forward to looking back on this in 5 years with you and seeing how your prognostications came out. It is like a laughable question. What is this going to look like in 5 years when we don't really know what it's going to look like in terms of AI technology in a month? However, regulation tends to move slow enough that it is maybe a little safer to say, okay, here's where I think it might be.
Yeah, I think for Europe, we've got some consistency now for the next 5 years. I don't think we're going to see landmark changes in AI regulation. They've got a lot to handle with this new law, so it's going to be bedding that in and seeing how people practically comply with that. So in the meantime, obviously, this remains a fascinating and interesting space. Will the bots take over? Will it just be you and I as sort of avatars doing this podcast in a few years? I'll just send my avatar to do it.
And it could get to a point where now AI is regulating itself and writing its own regulation.
Yeah.
We're all, this is silly. Flick, thank you so much. I know you must be very busy with everything that's going on, and I appreciate you coming back for another Legal Corner.
No, thank you so much for having me. Very much enjoyed the conversation.
And thank you to you all for listening to Between Two COOs. I'm your host, Michael Koenig, and a very special thank you to Flick Fisher. If you need any AI or privacy or GDPR, go to Flick. She's at Field Fisher out of San Francisco. She is the best along with her team. And tune in next time for our next chat on Between Two COOs, and be sure to subscribe on Apple Podcasts, Spotify, or wherever you listen so you never miss an episode. Just visit between2coos.com for more. Thanks for listening, and until next time, so long.